your license. By the time your license is suspended, people usually show up.
Yes, because now it directly affects me in a way that's much more severe,
Right.
and that was your point, obviously.
Exactly, because let's talk about what happens in East Greenwich. It's a $20 ticket. That's what our tickets normally are. Maybe even less, but
Let's move to East Greenwich.
Yeah, it's a $20 ticket. You don't pay it, it becomes a $40 ticket. You don't show up to court, now it's $40 plus court costs. You don't show up for that next hearing, it's now $40 plus court costs of $35, which is now $75, plus you now have that owner's liability ticket, which I believe is $50, plus another $35. You don't show up for that, now when your license is suspended, you have to pay another $75 on top of that to get your license reinstated. So now your $20 ticket is well into the hundreds.
Not to mention the time lost and the nuisance that this becomes
Correct.
as it compounds. Well, if we're not speaking to David as the judge, but David as the lawyer, at what point do people need to enlist your services? Parking ticket, no. Overtime parking, don't need your ticket, don't need
Right.
your assistance. Now we get into some of those moving violations, and there are a slew of them. Help us sort out when it makes a difference in the outcome or the ultimate cost.
Okay.
You have your first fender bender, and the insurance kicks in and the rest.
Mm-hmm.
When do we need you?
Well,
do we need you?
There are a couple of moving offenses that you're going to want to bring a lawyer for, and it really depends on you and your driving record. For example, remember I said you had to have no violations for 3
3
years,
years
to use the good driving statute?
Rhode Island and Mass?
I don't know Mass.
Don't know Mass. Okay, fair enough.
Rhode Island. You're driving for 2 years. You're a young child, a young person.
Young person.
And now you haven't been driving 3 years, so you can't use the good driving statute. You either want to go in front of the lawyer, or the judge, or perhaps even bring a lawyer so you can explain, this is a good kid, it's my first offense. Most courts, my court at least, I can't speak to every court, I would allow that person to do community service so that they get that free first bite at the apple. They've got a little warning now.
It's not on their record if they just do community service?
They do community service, pay the court costs or whatever it might be,
Yeah.
and then we'll dismiss the ticket after they've done that. If someone comes to me who's a younger person but has now accumulated a series of tickets and some other types of violations that might indicate making bad decisions, there's another program I'll send them to. It's called the RIDE program, which is Reducing Youthful Dangerous Decisions. And that's a program where that person will go to the emergency room and they'll spend a night there watching people be brought in for serious accidents or other things. Then they will be put through a little program where they give them these glasses that simulate what it's like to be under the influence, a couple of other things, and then they write a paper.
Is that the driving school situation of sorts?
It's another program.
Similar?
It's similar, run through Rhode Island Hospital.
Okay.
And I forget who actually administers it, but it's a really good program. And the idea is to let you know how serious you're driving, a weapon when you go down the street. And it's so that you take some more responsibility to see what the results are if you don't make good decisions.
A 16 or an 18-year-old not driving very long hits someone and has been drinking or is on drugs or has been truant or. In those scenarios, automatically, does that trigger we need David the lawyer or a lawyer
Right.
to represent them?
Once you start getting into the alcohol-related offenses.
Or drugs.
Or, yeah, it's called driving under the influence.
Whatever
it is. So once you're in those situations, you need a lawyer because they're very serious situations. And I started practicing in 1983, and I can tell you I've seen the evolution of the law on DUI refusal, and it is a very serious situation. It's a social problem that the legislature says is important to reducing those issues.
They're behind that.
And so they're behind it.
Mm-hmm. So what would a lawyer actually do, and how would you make a difference as a lawyer representing mom, dad, and the offensive youth?
Well, let's start with, and it doesn't have to be a youth with this situation.
Sure.
Someone comes into your office and they refuse the breathalyzer. They're charged with refusing the breathalyzer. They're charged with the DUI. And they start telling you the story. Why were they pulled over? Was there probable cause to pull them over in the first place? That's always a starting point. And then the statute's very specific on what they have to do in order to prove their case. For example, if you do take the breathalyzer, they have to mail the results to you right after you take them to your address on your driver's license. If they don't mail them to you, they're not admissible. So there are lawyers who actually specialize in these types of offenses.
Technicalities, though.
A lot of technicalities. And
good to know.
The statute's very technical. What are the steps you have to take? What has to be done to the machine that you take the breathalyzer on? I'm often asked two questions about DUI cases and refusal. If I'm pulled over, should I take the breathalyzer? And the other question is, if I'm going to have my license suspended, can I drive to work? They used to call it a Cinderella license. I can tell you in Rhode Island there is no such thing. If your license is suspended, your license is suspended. And on the refusal, I always say, if you're not going to pass the breathalyzer, well, in 1983 when I started, clearly you always refused the breathalyzer unless you hadn't had anything to drink.
SOP, standard operating procedure, so to speak.
Right. Now the rules are a little bit different. If you refuse the breathalyzer, the penalty is actually a little more severe, although it's not a criminal case, than the DUI case. But if your breathalyzer results are going to be so high that they go above 0.15, then your penalties are going to get enhanced anyways. So it's not as clear-cut an answer as it used to be.
If I have a lawyer, apart from the fact that a lawyer is going to say, gee, good person, will it make a difference in the outcome?
Well, let's say they double-dipped on you, which is what I call it when they charge you for refusing the breathalyzer and the DUI. Again, looking at all the technicalities, as we said, and the first technicality is what was the grounds for pulling you over in the first place. You still have to have probable cause to pull somebody over. It can make a big difference.
So you'd be able to flesh that out, or someone who is a lawyer would flesh all of those details out before you went into court, then present that as a case which either would maybe be mitigating circumstance, or would it lessen? It could lessen.
It could go from
charge.
lessening the charge to changing the charge to having a trial and beating the charge.
If you hit someone, is there ever an occasion where you wouldn't have a lawyer?
No.
You'd have to have a lawyer.
You definitely. You have two things there. You have the civil case, you have your insurance company who will have a lawyer represent you on that civil charge. If there's a criminal charge, you definitely need a lawyer to protect you on that. That's a very serious crime.
You're stopped because you were driving recklessly. Does that mean that you should have a lawyer, because isn't reckless somewhat arbitrary?
Yeah, there's a couple of interesting traffic statutes that you need to know about. Reckless driving, yeah, it's not arbitrary in the sense that there's no standard involved. But
good point of clarification.
Right, but you know, it is objective in some. I mean, subjective in some ways, as to what is reckless. Here's an interesting one that I've had a little research done on. There's the speeding statute, and one of the charges that they can charge a person with is reasonable and prudent speeds. So, what is it to drive in violation of the reasonable and prudent speed? If you're charged with just that, with no specific posted limit and what you were driving, that charge can't be sustained in Rhode Island anymore. There's an old case on it, State versus Campbell, that says arbitrary and prudent speed in and of itself is not, because you're not telling the driver what they did wrong, so they can't defend it, it's not sustainable as a charge. And some old police officers used to just write that statute number down without the other stuff, and if people didn't know that, they would go in and plead to a charge that can't be sustained.
And in that case, it would be worthwhile to have checked with a lawyer who would know the difference.
Well, you know, it's sort of interesting. It's the evolution of a statute, and historically, there was one statute for speeding and driving offenses, and they just lumped it all in at the early 60s, late 50s, or whatever. And then the legislature started breaking it out, and they had prima facie speeds. Now, interestingly enough, there was an old lawyer who challenged every traffic offense there was, and went to the Supreme Court on a number of them. And one of his things was that Rhode Island has an absolute speed limit, which is unconstitutional. You can't do that, because there are times when you need, because of the circumstances, to exceed the speed limit. And the prima facie speed limit, as it's set up in Rhode Island, is only prima facie. It's evidence of speeding. It's not proof